Listening 2513. Ms. Paulus is there for the state. Ms. Whiteway also for the state. Mr. Diaz for the defendant.
Good morning, Judge.
Good morning.
Oh, sorry.
Good morning, Ms. Gledhill. Mr. Diaz, what's planned today?
Your Honor, I believe we're going to set a motion hearing date. We've had the state and I have had the opportunity to talk. I think we have some agreement as far as a couple of the motions. I think there are two motions we're going to have to argue. So we're going to ask for, I believe, either a morning or an afternoon to argue those two motions.
What are the motions?
They are my motion in limine, and then the other one from the state involving the allowance of kind of the allegations, the facts that are set forth in the protective order that the state filed.
That's correct. It's defendant's motion in limine to exclude phone call recordings, and the state's motion in limine to exclude factual allegations in defendant's request for the protective order, and defense filed a response to that. At this point, the state has not filed a response to defendant's motion in limine to exclude the phone call recordings, but we anticipate we will likely, after the evidentiary hearing, ask for further briefing and then file a response.
Okay, so it sounds like we're not contemplating a motion argument hearing, but an evidentiary hearing.
That's correct, Your Honor.
Okay.
And what we're hoping, and the parties have discussed, is we'd like to provide the exhibits to Your Honor ahead of time to allow you to review them, and that will allow us to proceed a little bit more efficiently, and we'd be able to set it in, again, a morning or an afternoon.
And anything that happens by way of that, it would be stipulated as far as the court being able to review that beforehand.
Okay, as long as it's stipulated, I have no issue with that. And that would be helpful to have that information in advance. Okay, how far out are you on your schedules?
Well, Your Honor, it might make sense for us to discuss trial dates and then work backwards from there. I know that we're also hoping to set this back onto the trial calendar to keep things moving forward.
Okay. I'm trying to remember, I think we previously had like 7 days of trial.
We had 7 days of evidence and then an additional day for jury selection.
Right. Is that still your estimate?
Right now it is. What the state is anticipating is we're planning on meeting with many of the witnesses ahead of time to see if there's ones that we don't need to go forward with. Whenever you set a trial of this scope, you have a tendency to subpoena more than you probably would need, and so we're hoping to cut that back. But right now I think setting 7 days of evidence is necessary.
Okay. Let me see which of our trial settings would be able to accommodate 7 days, because normally we're
And I think just
4-day
so,
setting.
as the court's looking at its calendar, as we were speaking, I think the first set of dates we were looking at would be the June 8th date. I know that, was there a conflict in August? I can't remember. Conflict in August, so either the June or the September dates.
That's correct. And we understand there might be some situations where we might have to have some dates that are breaking it up a little bit. We're hoping to keep it as cohesive as possible.
The June date, I'd only be able to accommodate 6 days because we have Juneteenth observed on June 15th, and then I would run into other hearings. So if you wanted that, I could do 4 days the week of June 8th, and then it'd be June 16th and 17th.
Your Honor, at this point, speaking with Ms. Whiteway, we're just concerned that 6 days may not be enough. And so we'd have to maybe look at those September dates if you could accommodate more days.
Let me see here. I can't do that for September. I've got a civil trial that starts immediately after that trial week.
Do you want to try the June? Your Honor, is there an ability with the June dates to request an additional, a different date for jury selection, potentially seeing if the court could accommodate jury selection on maybe June 3rd or an alternative date that will give us more time?
I wouldn't have an objection to that. I should say I would be able to make that work.
That creates a logistical challenge in terms of jury pools and trial priority. Because I think I'd have to be pulling a different jury pool for just this case. And my final pretrial conferences for the other cases would then be after jury selection for this case. And right now, I think there's a higher priority case before this one for that June setting.
So,
Sorry, let me just throw out one other option here. If we did the June date, we'd have jury selection June 8th. We'd have the 4 days for the rest of that week. We could have the 16th and 17th the following week. The 18th is my preliminary hearing calendar, so we could have that afternoon.
and that was what Ms. Whiteway was suggesting, and I think that would be a nice, just in case it goes further than that, I think we could make that work.
I'm fine with that.
Okay, so let's see then. Let me double check one other thing. Okay, so we'll schedule jury selection for June 8th at 9:30 a.m. We'll schedule the trial days to be June 9th, 10th, 11th, 12th, and then into the next week, 16th, 17th, and the afternoon of June 18th. The two final pretrial conference dates are going to be May 7th and June 4th, both at 9 a.m. So with that set, we can schedule the evidentiary hearing for the motions.
And there's, after we set that date, we also have another motion that the state had filed. And speaking with Mr. Diaz, it sounds like he may wish to brief that issue, and so we were hoping to set deadlines as well. And we could probably set them around that evidentiary hearing time. So I'd like to build in a little bit of time in case we do have to litigate that issue as well.
Okay, but you got to give me time to make a ruling too.
Exactly, that makes sense as well, Your Honor.
So
So
well, the way I anticipate it happening is that motions would be filed, the evidentiary hearing would happen. As the state requested, there would be some supplemental briefing after the evidentiary hearing, and then we'd come back for a ruling. So I think the court would have ample time to make a ruling.
Jeremy, how much time do you have to look into the videos? When do
I have the afternoon of March 3rd as an option.
double check my calendar?
I could make that work.
Does that work for you? The afternoon of March 3rd? Let me just make sure. That works for the state as well, Your Honor.
We'll schedule the evidentiary hearing for March 3rd at 1 p.m. I'll block out the afternoon for that. So in terms of further briefing,
So I'll have, the response that I may give would happen in 3 weeks. And then if we want to give the state, if they choose to, 2 weeks to respond, that I think that'll get us around there. Again, I don't think it's a situation where it's going to require the court to make an immediate decision. Then I think we could come back after the evidentiary hearing and allow the court to make its decision from there and have final argument.
And it's not the state's intention with this potential other issue that we're briefing. We'd anticipate setting another evidentiary hearing. We just wanted to make sure we had time. So setting this evidentiary hearing on March 3rd will give us plenty of time to set something and know where we're at on that March 3rd date. My question to you, Your Honor, how soon would you like those exhibits to be able to review them before that hearing?
what's the volume of exhibits?
I'm not sure. So the state's position in regards to the protective order is none of the exhibits should come in. So we're anticipating that Mr. Diaz will be providing exhibits of the specific items he believes should be admissible. In regards to the phone calls, I neglected to look at the length, but there are a number of phone calls, but we do plan on providing transcripts. So I would think in regards to the states, I'd like to provide it with you at least 2 weeks ahead of time to just give you time to review them.
Just
And
looking at my schedule here.
And just so the court knows, we'll have a stipulated set of transcripts as well.
Yes, we're going to be working on that now to make sure that they're reviewed and both sides stipulate.
Any exhibits that are stipulated for the court to review in advance, it would be ideal if I had those by February 13th. That's a couple weeks in advance, and it'll,
Okay,
I think, give me enough time to review them.
that'll work.
Anything else we need to discuss today?
I don't believe so, Your Honor.
I don't believe so. I just want to note there were some other motions in regards to the reasonable doubt instruction and other arguments at trial. We both agree that that's something that could be handled closer to trial.
Could I have just a moment?
Sure.
That's it, Your Honor.
That's
Thank you.
all?
Yes.
All right. Then I'll see you on March 3rd. Thank you.
Great, thank you.
Thank you, and that's all I have today. Thank you. Nice
Thanks.
seeing you.